Welcome to today's web conference, Insider Trading in the Aftermath of Newman. Today's presenters are two Foley and Lardner partners, Beth Boland, National Chair of our Securities Enforcement and Litigation Practice, and Jonathan Halpern, who leads the Government Enforcement, Compliance, and White-Collar Defense Practice in our New York office. Before I turn the presentation over to them, I'd like to go over a few housekeeping tips. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you're looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, and you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please email the information to me, John Vickers, at jvickers@foley.com. To be eligible for CLE, you will need to log on to the On24 session and answer a polling question during the program. As a final note, those seeking Kansas, New York, or New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 4-digit code will be announced during the presentation. Please email the form to me, John Vickers, at that same email address immediately following the program. I will now turn the program over to Beth Boland.
Hi, good afternoon or good morning, everyone. My name is Beth Boland. As John said, I am the National Chair of Foley and Lardner's Securities Enforcement and Litigation Practice. I'm a veteran of many insider trading investigations and trials. We advise clients on their insider trading policies and compliance procedures. I am delighted to be here with my partner, Jonathan Halpern, who has joined us, leads our government enforcement practice in New York, but was longtime federal prosecutor with the Southern District of New York and he was the chief of their major crimes unit for many years. So hopefully we bring a wealth of expertise to this program, and we hope that you enjoy it. The topics that we are going to cover is just an overview of insider trading law to start with. We know that this audience is a pretty sophisticated audience. We've taken a look at the RSVP list, so we won't spend an awful lot of time on that. But we will talk about the philosophical underpinnings of the recent Newman case, which really is the source of the bulk of what we'll be talking about, and in particular, the Dirks versus SEC case that was the underpinnings of Newman. We'll talk about the Newman case itself and the securities market considerations for Newman, the SEC's use of Newman in administrative proceedings, and examples of DOJ and SEC actions post-Newman as well. Let's start real quickly, and all of these slides will be available to you all, and so I won't go over all of the information on some of them, especially these earlier slides, since I believe that much of this audience will know about the basics of insider trading. Obviously, the basic definition is buying or selling a security in breach of a fiduciary or other duty or other relationship of trust and confidence while in possession of material non-public information about the security. And because this is derived from 10b-5, there's no separate insider trading statute. This is all derived from 10b-5. 10b-5 requires manipulation and deception in the market, and that actually pulls back to a concept that we're going to talk about later in connection with the Dirks case. Liability can extend to those who tip information and those who receive tipped information and then trade on it. Criminal liability requires willful conduct, and civil liability requires reckless conduct in so doing. From the dawn of insider trading theory, the classical theory has really developed around the concept of insiders, corporate insiders, who take material non-public information that is entrusted to them by virtue of their insider status, and then they trade on it, or else they tip others to trade on it. And that is a breach of their fiduciary duty to their company or the company's shareholders. Those insiders can also take the form of corporate outsiders. Obviously, folks who have material non-public information about a company need not just be employees or directors or officers of that company, but there's a whole wealth of people outside of the company who possess such information as well, such as lawyers, investment bankers, printers, accountants, and so on and so forth. So the Supreme Court in the 1980s and 90s really grappled with this issue of how do we deal with these folks who are outside the company but nonetheless come into possession of material non-public information about the company while entrusted with that. Initially, the first case on that, many of you will recall, is the Wall Street printer case, the Chiarella case. And while the court reversed Chiarella's conviction, it opened itself to the concept that corporate outsiders, such as printers of M&A prospectuses, might be liable if they take the information from that impending deal that they're printing up and then use it to trade. This was all solidified in 1997 in the O'Hagan case, which involved an outside counsel to a company that was advising the company on a deal and tipped off some of his friends about that deal, and that now has become a solidified part of our jurisprudence, that such outsiders as printers and lawyers and accountants and auditors and investment bankers all, of course, maintain the same duty as company insiders once they are entrusted with material non-public information about the company. So the Supreme Court has, I think we skipped a couple of lines here. Okay, we're back to the classical theory, and now we talked about the corporate outsiders. And now what we wanted to do is to talk about the Dirks case. Okay? Dirks was really established a couple of things. Not only was the Supreme Court grappling with this issue of who are insiders and who are outsiders in the background, but Dirks in 1983 was also grappling with the nature of what insider trading itself, the offense, consists of. Is stolen information more like a stolen car, where you only need to know the fact that you have a stolen car? One need not know anything about the motives or the benefits or anything else about the original thief, but if you have a stolen car, that in and of itself is a violation of the law. And in the Dirks case, the Supreme Court was dealing with this theory that was pushed, obviously, by the government. They were hoping that anyone who had material non-public information, stolen information from a company, regardless of how it came into their possession, that they could not trade on that. And so Dirks had to decide, the Supreme Court needed to decide in that decision, is mere possession of material non-public information enough to trigger liability? And the court came back with a resounding no. And the rationale behind that is important for us to determine and understand the genesis of what has happened since then. Let's talk about the facts of the case. That case is actually a classic insider trading theory case. You had a corporate insider, actually a former corporate insider. He was an ex-insurance company insider who believed that his former company was overstating its profits because of internal fraud. He went to various regulatory agencies and notified them, but they failed to act. So what did he do? He went to a fellow by the name of Dirks, who was an analyst for a broker-dealer, and told him about that fraud. Obviously, material non-public information being told to somebody outside the company by a former corporate insider. Dirks, in turn, spoke with other employees to verify this information. Senior management denied the fraud. Dirks went to the Wall Street Journal, notified them, but they wouldn't pick up the story. Interestingly, neither Dirks individually nor the broker-dealer traded in the stock, but what they did do is they told some of their customers, some of their clients, some of their investors about their beliefs about the fraud going on in this insurance company, and those folks traded. So the U.S. Supreme Court wanted to make sure that those who passed along material non-public information for a, quote, good purpose were not going to be held liable under insider trading laws. It's not like a stolen car. Regardless of how you got the information, that you have liability, there has to have been something more than mere possession that gets one into trouble. Interestingly, the Justice Powell, who wrote the decision, was in trying to formulate how to capture this concept of good versus bad intentions, initially focused on a, quote, good faith purpose, and that was going to be the standard. But Justice O'Connor, and this is all according to a book written about Powell by one of his clerks afterwards, apparently Justice O'Connor pushed back and said that's too squishy. We need to have a more objective standard. And so what they settled on was this personal benefit standard in order to separate out the, quote, good insider trading, good flow of material non-public information for good purposes from the bad purposes. The standard that the court came up with said, well, these guys aren't liable because they traded for in order to expose fraud, but the people who would be liable are those who either traded or tipped for personal benefit. Powell also wanted to protect communications with investment analysts. Some folks speculate that he was egged on by a clerk who was an efficient markets devotee, but you see some important language in this decision, in the final bullet point here, about the value of the free flow of information to analysts. As an aside, out of this particular passage flowed the selective disclosure of information to analysts, from a company to analysts, and then that was superseded by Reg FD. But nonetheless, the important piece is that this piece on the analyst was something that was important to the court, and it forms a core for some concepts that we're going to talk about later vis-a-vis Newman. Okay, now we now see some of the slides that had gone out of order. We had talked before about insider trading and the outsiders, and the SEC ruled 10b-5-2 gave us some guidance about who's an insider or what type of trust or confidence does one need to have in order to be an outsider and still be liable for insider trading liability. Let me see if I can skip ahead to the correct slides coming after in the wake of the Dirks decision. Okay, here we are. Sorry about that. For Tippee, the Dirks case was really focused more on the tipper. We had a corporate insider who was provided information. What type of duty, what type of motivation did he have when he was passing along information to others? On the Tippee side, what does the Tippee need to have done? They need to know that the insider held a fiduciary duty. They need to know that the insider breached his fiduciary duty by disclosing that material non-public information to the Tippee. And now, under Dirks, there is this concept of the personal benefit. So we have it very clear that the tipper had to have a personal benefit, and the question now, in the wake of Dirks, is what kind of knowledge about that personal benefit did the Tippee need to know about? So let's look at the language that Dirks used about what that personal benefit entailed. And this language is very important. Remember, it was just drawn up as a compromise type of position, and you see all the nuances and all the holes that come up because of that compromise. You see that there is no breach of duty unless the personal benefit is received in exchange for disclosure. According to the court, a breach of duty occurs if, quote, the insider will benefit directly or indirectly, and that last piece is an important piece, as we'll see, from his disclosure. Absent some personal gain, there has been no breach of duty. The court went on to talk about what types of things constituted personal gain, personal benefit, and which types of things did not. The duty, for example, would arise from the relationship between the parties, not merely one's ability to acquire information because of its position in the market. So the relationship between the parties is important. The court also noted that whether the insider, quote, receives a pecuniary gain or, again, this is the broader language that many later courts hooked into, or reputational benefit that will translate into future earnings. There's the court will also focus on whether there is a relationship between the insider and the recipient that suggests a quid pro quo, or a gift of such as a gift of confidential information to a trading relative or a friend. And since Dirks, as we talked about, had disclosed his information, his material non-public information from the company, taken from the company to expose fraud, but not for his own personal benefit, there is no liability for the insider himself. Okay, so in the wake of Dirks, and in particular, the phraseology that the Dirks court used about what is personal benefit and what is not, you see a couple of things happening. Number one, the first thing that the SEC did in response to this outcome, this negative outcome in their view, was they pushed back on the idea that this personal benefit rationale would be applied to the misappropriation theory, to the outsiders, the corporate outsiders that we talked about. Recall that in Dirks, it was a corporate insider, and so the SEC tried to limit this new theory to just information taken by corporate insiders. By 2012, the Second Circuit had quashed that idea, and it was clear that this personal benefit theory was going to be applied across the board, whether one was a corporate insider or an outsider. But more importantly, that language, that very squishy language for that Justice Powell used in Dirks about what constituted, quote, personal benefit, was like, that was a hole that was as wide as a bus could drive through. And there were many passengers that tried to get on that bus after that decision. We list here a number of cases in the wake of Dirks that really show that virtually anything could qualify as a personal benefit in the wake of that decision. By the time the Second Circuit had reached this very key case at the bottom of your screen, SEC versus OBUS in 2012, really, the concept of personal benefit had been worn down to a nub, and in fact so much so that when the Second Circuit articulated the standard for Tippee liability in that Obis case, they didn't even mention a requirement that the tippee must know about not only that the tipper, the original person with the information, had violated their duty of confidentiality, but that they know that it was done for a personal benefit. So by 2012, we had gotten to the point where we believe that where many courts, including the Second Circuit, arguably had interpreted personal benefit in a way that may or may not have been intended by the original Supreme Court in Dirks, at least as it applied to Tippee liability. For tipper liability, I think it is very, very clear that the tipper needed to have not only breached their duty of confidentiality, but also to have obtained a personal benefit. So then the question is, what did the tippee have to know about in order to get tippee liability? So that brings us to the Newman case, classical insider trading scenario, but you have very remote tippees in that case. And my partner Jonathan is going to talk about the case, talk about the facts behind it, and what the implications are for insider trading theory in the wake of that.
Okay, thank you very much, Beth. Good afternoon, good morning, and perhaps good evening to you all. So here is Newman, the summary of the facts. The Second Circuit had said that they had not been able to find a single case in which tippees were as remote as they were in the Newman case, Newman and Chiasen. The government hadn't been able to identify one, neither had the court. And so this was as a case of an issue of first impression when the court was presented with the question, the issue, whether tippee's knowledge of a tipper's breach required the knowledge of the tippee's personal benefit. And the court said that the ruling flowed directly from Dirks, the exchange of confidential information for personal benefit. It's not separate from an insider's breach. It is the fiduciary breach that triggers liabilities for securities fraud. And the court is saying essentially that, and we'll go on to discuss this some more, but mere disclosure of confidential information is not enough to trigger criminal liability. And so the government was required to prove, in this case, that a tippee knows of the personal benefit that the insider received in exchange for and consideration for the material non-public information. Without that, the government is just not able to prove that the tippee knew of the breach. And the court is very clear about this and also very disturbed about, in this case, the lack of evidence coupled with the remoteness of the defendants, the tippees, to the corporate insiders. And essentially they bring the government to task for relying on what the court said was prior dicta, but all that did was underscore the doctrinal novelty of these prosecutions of remote tippees. Tippees not in direct privity with the insider tipper. So let's see, what was the close of the evidence? Let's see if I can skip ahead here. We got the trial court's rulings. Summary of the facts. Okay, the insiders at the two companies, these were employees, had disclosed to financial analysts company earnings numbers before they were publicly released. These were employees from the Investor Relations Department. The analysts passed the information, the confidential information, to their portfolio managers, and then included the defendants Newman and Chiasson. Newman traded at $4 million in profits, Chiasson $68 million, and based on the kind of linkage of disclosures, Newman and Chiasson were 3 and 4 levels removed from the insider tipper, respectively, for Dell in respect to the trading in the Dell stock, and each were 4 levels removed for NVIDIA. What was disturbing to the court in particular was that there was no evidence that either defendant knew the source of the MNPI. No one, including Newman, knew that the information came from an insider, a corporate insider. And here was the government's theory of criminal liability. These were sophisticated defendants, traders. They must have known that the MNPI was disclosed by insiders in breach of a fiduciary duty and not for a legitimate corporate purpose. So at the end of the evidence, the defendants ruled for judgment of acquittal in the Rule 29 motion, and which said essentially this, that there was zero evidence that the insiders exchanged the confidential information, the MNPI, for a personal benefit under the Dirks rulings. Because Tippee liability derives from the tippers, the traders themselves cannot be liable as a matter of law. So even if the insiders had received a personal benefit in exchange, and the court says there was scant evidence of that, but there was no evidence, zero, of the traders' knowledge. Without the knowledge, the traders then could not be participants in a fraudulent breach of a fiduciary duty and therefore could not be convicted of insider trading under the Dirks rulings that Beth discussed. The defendant's request for a jury instruction was an alternate for the Rule 29 motion relief, and they essentially said in order to convict, the judge must find that the defendants knew the insiders had disclosed the confidential information for a personal benefit. That was the request to the court, which the district court did not give. It reserved at the time on the Rule 29 motion, ultimately denied it. But here's what Judge Sullivan's jury instruction on the defendant's knowledge was, and this was, of course, over the defendant's objection, that the mere receipt of material non-public information, even if traded on, was insufficient, that is, insufficient for a conviction. The government must prove that the defendant must have known that the MNPI was originally disclosed by the insider in violation of a duty of confidentiality. The judge did not give any instruction to the jury as to the defendant's knowledge of a personal benefit. And that was the a key rub in this case, as the Second Circuit ruled, and as it narrowed the standard for Tippee knowledge, it said that the jury instruction incorrectly permitted the jury to find the defendants guilty if it found they knew that an insider had disclosed confidential information. That's because that's only one of the two components of the breach of fiduciary duty, that is, the duty owed to the corporation or its shareholders. And that's what it says, that the breach of duty of confidentiality is not fraudulent unless the confidential information was exchanged for a personal benefit. And the court's ruling comports with a mens rea requirement that the defendant know the facts that make his conduct illegal. As a statutory element of commission of a crime, willfulness is required, and unlike that for civil case, as we'll discuss in a little bit, willful conduct reflects intentional, purposeful, voluntary conduct, where there's some recognition of wrongdoing. It's not accidental or negligent, which would further define civil liability, at least as an element of civil liability. So the standard for Tippee knowledge, as the court says, the jury is required to find that the Tippees knew that the insider disclosed for personal evidence, and the court found that there was no evidence that the defendants knew the information they were trading on was from insiders or for any insider benefit, or they said that there was no evidence that they consciously avoided learning the facts. And conscious avoidance is be a substitute for the element of criminal knowledge. We'll get into some of the facts, the evidence that the defense elicited during the course of the trial, and that the circuit referred to indicate that really there's no indication of criminal knowledge, or that the defendants here did anything either that was directly wrong or indirectly, and they didn't cover their eyes. They didn't have an obligation under the facts, the evidence that the government elicited, to delve in more, to discover, to ask additional questions. So the second part, apart from actual the legal standard for Tippee liability in determining its knowledge that the insider breached a fiduciary duty by disclosing confidential information in exchange for a personal benefit, was the court went on to define with some greater clarity, but not entirely, what a personal benefit is. And so the court acknowledges that it's a broadly defined term. It's not limited to pecuniary gain, but more likely it ruled out what didn't constitute a personal benefit. So, for example, a mere casual or social-based friendship was insufficient, and that's what was one of the relationships in this Newman case. So, for example, the court said just being a member of the same church or house of worship or sharing an alma mater was not enough, because if that were the case, then practically anything constitutes a personal benefit born of friendship, and that would effectively be a nullity. So where the court says if the personal benefit springs from a personal relationship, there has to be more definition, more contour to that relationship. And there has to be evidence that proves that it's meaningfully close, that somehow generates an exchange that is objective, consequential, and represents at least a potential gain of a pecuniary or similarly valuable nature. So something that either is or would generate a quid pro quo from the recipient, or an intention to benefit the recipient. That is, an intention by the tipper to benefit the tippee would be an example of that. It goes on to say that it has to be more than this kind of fleeting or ephemeral value of friendship, and the court termed the evidence that was submitted here as scant evidence that was insufficient to establish a personal benefit to the tipper, to the insider here. In this case, with respect to the Dell stock, there was career advice from the analyst to the investor relations staffer, the tipper, encouragement of a fellow alumnus or casual acquaintance. In this case, that there was evidence that the testimony was that kind of advice began a year before the disclosure started. And the witness testified that was advice that he routinely provided, and not just to Ray, the investor relations staffer, but to his colleagues in the industry. And with NVIDIA, it was even less significant, and that's probably elevating the standard by saying it's significant. Here, the two were casual acquaintances, and according to Lim, Joy did not even know that Lim was trading the stock. So the court found essentially two things that, and this is very rare because when there are challenges based on the insufficiency of the evidence, there are challenges that are very difficult to surmount, and all the inferences of the evidence favor the government. But nonetheless, in this particular case, they said it was scant, it was insufficient. Even if it were insufficient, there was absolutely zero evidence that either of the two defendants knew about that personal benefit. In fact, they said that there was no evidence that the defendants knew that the source of the information was a corporate insider. Okay. What the government must prove to convict Tippees of insider trading. So this was the test, so far limited in the Second Circuit under Newman, but certainly can be persuasive. And as we'll see, some challenges are leaning to adopting it, some are under review, and other courts are distinguishing a very fact-based determination in their particular case from that in Newman. So here's the test. One, that this is again to prove the conviction of Tippees of insider trading. The insider held a fiduciary duty. The insider breached his fiduciary duty by 1, disclosing MNPI to a Tippee, and 2, in exchange for a personal benefit. The Tippee knew of the tipper's breach, that is, that the insider knew the information was both confidential and disclosed in exchange for a personal benefit. And the Tippee used that MNPI to trade in a security or to tip someone else, another individual, for a personal benefit in return. So the aftermath of Newman, at least in the Second Circuit, and there are ramifications elsewhere. First, and certainly to be expected, insider trading prosecutions, especially of downstream Tippees, expected to drop. These are remote Tippees, and you can almost feel from the language of Newman that the court's almost taken aback by an approach of the prosecutions to go so far downstream. As the court says in the cases that they've been dealing with, the courts have been focused on Tippees that have more of a direct relationship with the tipper, or if they're removed, the evidence is pretty substantial, pretty concrete. Their awareness of a personal benefit that was bestowed, in part because they were the ones who were providing that personal benefit. So, as we say here, the Second Circuit makes note of the doctrinal novelty of these kinds of prosecutions that are aimed at remote Tippees that are several levels or generations removed from corporate insiders. As a result, there's an increased burden of evidence that the court has imposed on prosecutors to prove convictions of Tippees. And they've restored the knowledge element here, so that as an element of a crime like in securities fraud, you have to know that what you're doing is wrongful. There's a willful element, and it's just not by accident or inadvertence or negligent or even reckless. And that you can't have that criminal knowledge element here without imposing on the government the obligation to prove that the tippee, in this case the defendant, knew that the tipper had breached his obligation, his duty of a fiduciary to the corporation and shareholders, because he not just disclosed the confidential information, but did so in exchange for a personal benefit. Okay, and what is the court going on beyond assessing the elements and creating the standard for a personal benefit and knowledge? What they're really doing is looking at the evidence and the realities of the securities market operations, what's going on in the street. And I think that's instructive for future cases, and it really shows kind of a healthy dose of an appreciation, application of the law as it's designed to the realities of the market, and that it's not necessarily about creating equity among information of those who are trading in the market, but rather it's about whether there's a violation of duty as a fiduciary, or in the misappropriator context, whether there's a violation of confidentiality. And this goes back to a series of cases, Supreme Court and Second Circuit cases, going back to Chiarella, Dirks, as Beth talked about, but also in the Second Circuit case, going back to 1991, the Chestman case, where Judge Winter, in a concurring opinion, says the policy rationale for prohibiting insider trading stops well short of prohibiting all trading on material non-public information. The efficient capital markets depend on the protection of property rights and information. However, they also require that persons who acquire and act on information about companies be able to profit from the information that they generate. So the court, as it says, is not concerned about informational asymmetries. That's from Newman. And what they're saying is, and they're just drawing on Chiarella and Dirks, and they're saying that element's a critical limitation on insider trading liability that protects a corporation's interest in confidentiality while promoting efficiency in the nation's markets.
And John,
yeah.
John, this is Beth. We had a question that relates kind of very directly to that issue, if you don't mind us jumping in on that.
Sure.
And that has to do with, we were posed a question about what happens if an analyst, for example, gets information from a customer or an employee or somebody who is not affiliated with the target company, but rather the target company's outside suppliers and so on. And this actually, the typical example might be, you might call up a supplier to Apple and say, what's your order flow look like? You know, is Apple ordering a bunch of supplies from you or parts from you, which would suggest that their sales are potentially going to go up because, you know, the suppliers' chains are going up. And I think the answer to that is based on the theory that Jonathan was just explaining, that not all material non-public information is actionable. It all has to tie back to that duty to the original company. So in the scenario that I just posed that was asked about, you wouldn't be liable for insider trading liability, because that really, the information and the breach has to relate to the company in whose stock you are trading. But you could very well be liable for aiding and abetting a breach of confidentiality if you're, applying information from a supplier to a company whose stock you are trading in. That could absolutely be aiding and abetting a breach of confidentiality that employer, that supplier owes to, that employee owes to its company, or most suppliers have confidentiality agreements with their companies that they're supplying parts or labor or service or whatever to, that prevents them from providing that information outside to some outsider. So, Jonathan, I don't know if you have any other thoughts on that particular scenario.
Yeah, it would just be also possibly under a misappropriation theory, building what you're saying, that if it's known or should have known that the information is supplied based on a confidential relationship, there's an understanding that the information is not to be traded on or tipped to another, that could constitute, a violation, and that would just be under, even from an outsider, if there is that relationship with the In this case, it would be an unwitting provider, an unwitting tipper.
Right. So, in other words, what you're postulating is that if the information actually relates to the company in which you are, in whose stock you are trading, and that order flow was provided to the supplier by the company, and the supplier then, breaches that, then you could potentially fit that back into insider trading theory. So either way, it could either potentially be under insider trading. It's a harder fit depending on that relationship with the outside supplier, but you certainly can have liability for engaging them to breach their own duty of confidentiality to their own company.
Right. And this kind of fits in with the flow of information that I think the Second Circuit was touching on here, where there's a recognition what investor relations departments routinely do. They're assisting analysts with developing their models. They're responding to questions, and there was evidence that in Newman that analysts call up and they're before their public announcements and after they're modeling earnings and other data, and they're asking whether their assumptions are in the ballpark. Are they right, too low, too high? And their responses. And the court draws the inference that these numbers get updated in advance of public announcements. And so it's not uncommon for companies themselves to leak earnings data and other financial information. And they do that, the court implies, in their self-interest. And they're saying, look, you can't ascribe criminal accountability to these Tippees under these kind of industry circumstances, where they're saying corporate insiders regularly engage analysts and selectively disclose information, and they do that routinely. And under that whole mix of information, notwithstanding how detailed and precise it was, the government says it's so detailed and so precise that these sophisticated traders had to have known that the source was inside and could not have been disclosed for a legitimate purpose. The Second Circuit says no, not here. There's a different inference, and there's no conscious avoidance. There's no obligation under all these facts and circumstances for Newman or Triason to do anything and make further inquiry. So I think this is really kind of a rebuke of the government's theory and its sense of what's right and not about corporate governance on the street in the securities market. Anyhow, that's my view. And essentially they say the financial information in this case was kind of the type that's regularly and accurately predicted by analyst modeling, even outside of what was deemed to be material non-public inside information. So what are some additional implications of Newman? Imposing a duty to disclose or abstain solely because a person knowingly receives MNPI from an insider and trades on it could have an inhibiting influence on the role of market analysts. And that's what they're trying to avoid here. I mean, the court's not a policy maker, but I think there is policy that infuses and informs the legal doctrine that the court is applying here. And it says it flows just naturally from Dirks. So here, the Newman ruling may reduce inhibiting influence on the role of market analysts. They cite that the SEC recognizes the role of market analysts as necessary to the preservation of a healthy market, and that's coming from Dirks. And they give the example of a whistleblower, and that's the Dirks case, and really goes to what is the motivation behind the disclosure. In Dirks, they were saying it was for a good purpose. It was to uncover securities fraud. It may not be the conventional way of making such disclosures, but it wasn't for a personal, pecuniary, or other benefit, and therefore there's no criminal liability. And especially in these circumstances where the analysts are meeting with corporate insiders to learn information, as they say, essentially they're doing their job. They're ferreting out and analyzing information. They're questioning corporate officers with information, and they're preparing reports. So again, the recognition of real-world realities here that are non-criminal in the court's view, recognition of the important role that analysts play in identifying and revealing information to the public, and it need not be tidy and precise and even, and so that there is a level playing field so that everyone can act at the same time on all of the information. Again, the court saying what's really at stake here is the importance of whether a duty of confidentiality or fiduciary duty is upheld. And so they go on. Here's evidence that analysts routinely estimate revenue, margins, earnings through legitimate financial modeling with publicly available information and educated assumptions about industry and company trends. Again, there's an appreciation here for the liberal discourse among the street and among corporate insiders. It's not saying that it's not doing away with the rule against trading for personal benefit or tipping another to trade on material non-public information, but they're really doing a deep dive into the particular facts and circumstances of each case. And it repeats kind of a long-standing doctrine that there's no general duty between all participants in market transactions to forego actions based on material non-public information. And it's just not, all disclosures not inconsistent with the duty owed to a corporation or its shareholders. And this kind of implicates a little bit the Mosaic theory of materiality, which recognizes that there can be an increase in a value of an analysis when traders are able to kind of link together both non-material, non-public information and material public information and use that Mosaic. Regulation FD, fair disclosure, requires disclosure more broadly when there is a selective disclosure of material non-public information, selective to various market professionals and analysts. In this way, the regulation requires the issuer to make public disclosure of that information. And here, they're saying when the information is not material or immaterial, they don't have the same obligations. And materiality, perhaps unfairly, is judged by hindsight. So,
Jonathan?
Yeah.
Excuse me. I need to interrupt for just a moment to announce the CLE code information. We're obliged to with programs like this, so if I could just take a minute. At this time, I'm going to read the CLE code for this program. If you wish to receive CLE credit from today's program, please enter this 4-digit code into the poll question on the screen after it is announced and press the Submit button. The code is SO9T. That's S as in Sierra, O as in Oscar, numeral 9, T as in Tango. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget. Thank you.
Okay. So can we go to slide 28? Let's see, will that do it? Limitations on applying Newman. Yes. All right. Yes. So what are some limitations as to how Newman's applied? First, right now, it's limited to prosecutions and civil actions brought within the Second Circuit, though other courts may deem it persuasive. And there are courts outside of the Second Circuit and even within that may distinguish or at least distinguish from the standard. Outside may determine that it's a standard they don't care to adopt. There's a Fourth Circuit case pending now where both down below and the circuit denied a motion for bail pending appeal in the circuit for a stay pending appeal on Newman's grounds. And right in the district court in the Southern District of New York, in Riley, the district judge determined that there was a personal benefit. This is in a post-Newman, the trial was pre-Newman. The Judge Caproni said that had Newman been the law, she would have provided a Newman instruction, but in any event, it was not plain error. And in that particular case, the evidence was rather modest. It was a tip given to, quote, maintain or further a friendship. I think that was included in the judge's instruction to the jury. The court held that was circumstantial evidence of a quid pro quo relationship in order to maintain or further a friendship. There may be inconsistent with kind of the rationale of Newman as to what constitutes a personal benefit, especially in light of its assertions about casual friendships or social friendships. So no doubt we expect to see that one on appeal. All right, other limitations. Well, prosecutors and SEC lawyers may turn to other jurisdictions outside of the SEC, outside of the Second Circuit, rather. And we're beginning to see, at least there's one example recently in the Southern District of prosecutors and investigators seeking to focus on the element of personal benefit and developing evidence to support the personal benefit and Tippee knowledge. Other cases, and this is just a relatively small point, but and the Second Circuit in Newman was very clear that the standard applies to both classical misappropriation cases, though it was a classical case in Newman. SEC is looking increasingly to administrative proceedings rather than district courts as a forum. There still may be a petition to the Supreme Court from the Second Circuit's ruling. And a number of these issues are extremely fact-dependent. What constitutes knowledge, what constitutes a personal benefit, have to be parsed, and it's very difficult to do in real time. We're thinking in the future. And as we've seen in one case before, Judge Rakoff recently, where there was a dismissal of the criminal prosecution, Judge Rakoff held that under a civil standard, a reckless standard, the SEC had properly pled allegations from which it could be inferred that there was a sufficient personal benefit. And all in all, there's an extraordinary toll, an extraordinary cost in terms of personal, financial, career, reputational toll just defending against these kinds of charges or an investigation that might lead to a charge. So here's some additional aftermath issues of Newman. There are ongoing challenges. There are approximately 20 or so in the district and appellate courts, various claims. Several courts have rejected arguments that Newman is a bar to conviction. Again, there's an issue of mere friendship cases, whether under Dirks or Pre-Newman, those cases would survive this tightened standard requiring a close personal relationship that, quote, generates an exchange that is objective, consequential, and represents at least a potential gain of a pecuniary or similarly valuable nature. The SEC, according to Mary Jo White, the chair, views Newman as overly narrow view of insider trading law, and there are routes that the SEC can take, including by reverting to administrative proceedings and bringing claims in other jurisdictions that can perhaps sidestep the rulings of Newman. But as the courts recognize, there are legitimate reasons for insiders to disclose inside information to an outsider, and among these, Judge Rakoff just identified a whistleblower disclosing a fraud, as well as an insider carrying out his company's policies on priming the market. That was Judge Rakoff's wording, by disclosing to analysts before a public announcement. I'm going to try and speed up a little bit the last few slides. And there are other examples of how justice and the SEC may be adapting to Newman's ruling. There are going to be continuing prosecutions and claims where there is concrete, substantive evidence of a direct and tangible personal benefit, whether it's a kickback of some of the proceeds of the profits by the Tippee who traded on Tipper's tip. This recent criminal complaint and civil claim in the Stewart case in the Southern District of New York, the criminal complaint alleged that a cooperating witness had asked the Tippee if his son, the tipper, had done so out of the goodness and kindness of his heart, presumably to elicit evidence that would suggest there was a personal benefit. And the complaint reflected some tangible benefits, such as a payment to the son's wedding photographer at the son's wedding and another transfer of $15,000 or so. One challenge to the obligation to pay disgorge the Tippees' profits was unsuccessful. The tipper was still obligated to do so. So other pursuits, we talked about that the SEC most likely will be pursuing relief in the administrative proceedings. It routinely has said it will do so. Some of the differences from district courts, there's a shorter timeline, generally up to 300 days from institution, but could be fewer days than that, with notice from the SEC. There's limited discovery. Generally, depositions are disallowed. Federal rules of evidence generally don't apply, so hearsay can come in. There's no right to jury trial. And then you've got the kind of institutional issues about an employee of the SEC being the fact finder, review by the commissioners who originally voted to bring the enforcement action, and then there's an appeal from the administrative proceedings to federal courts. And we're probably most familiar with the kinds of advantages that have been discussed that favor the SEC in administrative proceedings, and that their rates are significantly higher, at least in the last 2 years, in cases brought before APs than in district court cases. And there's an issue, though, about, and this has been raised in a number of panels and by commentators, about whether there's the same degree of kind of institutional truth-seeking in an administrative proceeding when you don't have depositions and vigorous discovery, and the rules of hearsay don't apply. So I think those are legitimate issues, but challenges on constitutionality to these administrative proceedings have not been successful generally so far. Here are just a couple of examples of SEC and DOJ actions. This was SEC versus Payton and Durant before Judge Rakoff. I referred to this earlier. The motion to dismiss the complaint was denied. Notwithstanding the dismissal of criminal charges, Judge Rakoff recognized a lower civil standard, recklessness, not willfulness. Said that the SEC met the pleading standard with inferences that favor the pleader, the SEC in this case. And what were the allegations of personal benefit to the tipper in this case? They reflected a close, mutually dependent financial relationship. There had been an ongoing history of personal favors. The tippee assisted the tipper with a criminal legal matter, and the tipper had thanked the tippee for prior assistance and expressed happiness over the tippee's profits from trading because of the prior help. A case out of Massachusetts, and this is an example, may have reflected the question from the questioner, and that is that when you have the source of the MNPI is an unwitting executive in this particular case and a participant in the chain to the tipper that was betrayed, the personal benefit need not be alleged or proved to inure to the benefit of that unwitting participant. And so the indictment alleged that the tipper received a benefit or that the tippee knew that the tipper would receive an unexpected, that the tippee knew that the tipper would receive or expect to receive the benefit. So here, the court held that at least as alleged in the indictment, this is a criminal case of the District of Massachusetts, there was a requisite relationship of trust or confidence that was sufficient to generate the understanding that confidences would not be disclosed. And that may implicate the questioner's issue that was raised. So there had been a pattern and practice of shared confidences. The court nonetheless credited Newman as persuasive, but under the facts of that particular case, denied it, and there was a reliance on the Supreme Court case of O'Hagan. So where are we at the end of the Newman decision, and as we look forward, certainly the standards for Tippee liability have been tightened, narrower in its application for prosecutions than in SEC cases. There's a requirement of criminal knowledge of both components of the breach of duty element of insider trading, the duty of confidentiality and the knowledge of a consequential personal benefit to the tipper in exchange for the tip. There's clear notice of what constitutes actionable insider trading. There's a greater burden on the government to convict downstream tippees, especially remote tippees, several generations removed from the corporate insider, and we should expect that those will decrease absent really tangible, concrete, substantial evidence of the tippee's knowledge and of the benefit to the tipper. And on a policy level, it does, as the Newman decision makes clear, that prosecutions of remote tippees may be misdirected, and they may not be as sensitive as they could to what's going on in the market, the common and innocent discourse that generally occurs between corporate insiders and analysts. I think that sums it up. I don't know if we have a time for any questions, but I'll turn it over to John, and thank you for your time and attention. And if you do have any follow-up questions, Beth and I would be happy to address them either now or offline.
Jonathan, if I could interrupt one more time, we've gotten some messages from some folks who said that we didn't leave the screen open long enough for them to fill in the CLE code. So we're displaying it again for those who need to complete it. And just to repeat the code, it was S as in Sierra, O as in Oscar, numeral 9, T as in Tango. We'll leave it open for another 15 seconds or so.
Okay, so while you leave that open, I think that we'll be done with the program. We appreciate everybody's attendance, and we appreciate the questions that were posed in the Q&A, and we hope that you all get your CLE code in and get credit for it. and that you learned a few items during the course of our presentation today. Thank you all.